Welcome to A Better Divorce podcast, where we have conversations about the emotional, financial, and legal issues that are on your mind or should be on your radar if your goal is to keep your divorce out of court. I'm collaborative divorce attorney and mediator Andrea Vacca, and I know that how you divorce matters to your long-term well-being. That's why it's my mission to help you have a better divorce with as little acrimony as possible, so that you can create the best life possible on the other side of your marriage. Hi, I'm happy to welcome Michael Gooen to A Better Divorce podcast today. Michael is a partner in the law firm of Lowenstein Sandler, where he co-chairs the firm's family office group. He's a fellow of the American College of Trust and Estate Counsel and has been recognized by Chambers High Net Worth. For over 30 years, Michael's been designing and implementing wealth transfer plans for families and closely held businesses. Michael, welcome to A Better Divorce podcast. I'm
Thank
so
you
happy.
very much, Andrea. I'm smiling because I'm seeing the title "A Better Divorce with Michael Gooen," and I just hope my wife doesn't see this.
We'll keep it a secret, okay? I'm so happy you could join me today because it's such an important intersection between divorce and estate planning, and not everybody thinks about that. So
No, I agree. In fact, I appreciate this opportunity because I've collaborated with divorce lawyers on prenuptial agreements. I've consulted with them during the pendency of divorces. But if there's anything I've learned, it's that dialogue between lawyers who do what I do, the trust and estate side, and lawyers who do what you do, the divorce side, doesn't happen as often as it should. Anytime we get a chance to have this conversation, it's a good thing.
I completely agree. Like you, I've been practicing law about 30 years as well. And I with all the couples I've helped divorce over that time, I consistently see that it's usually not the top of their mind to think about how their trusts and wills and overall estate planning will be handled after the marriage ends. And and then I have to have that conversation with them about, you need to go find someone like Michael to talk to. So hopefully this conversation will shine a light on anyone who's listening and contemplating divorce or in the middle of a divorce about some of the issues they should be keeping in mind before their lawyer tells them to keep it in mind. So what would you say the most important estate planning considerations are that somebody should be thinking about when they're divorcing?
Sure. Well, divorce is a disruption, and it's something that people don't frequently contemplate when they go into an estate plan, just like they don't frequently contemplate it when they go into a marriage. Maybe they have a prenuptial agreement, maybe they don't, but divorce is not something anyone shoots for. And there may be provisions that they've made in their plan. Perhaps they're irrevocable provisions. They've created trusts for the benefit of their soon-to-be ex-spouses, but they've worked on the assumption that they're married and that they're an economic unit. And divorce obviously is a major game changer. What happens when if a couple that I'm representing tells me that they're about to divorce, if I represent both of them, then I'm conflicted out of the process. I have to step back and say, each of you go to your separate corners, talk to your own lawyers about what you can and can't do, and I become an informational resource, but I can't do work for either end of the couple. If an individual I'm representing, where I don't represent the soon-to-be ex-spouse, comes to see me, I still say, go and talk to Andrea or talk to your other divorce lawyer about what you are and aren't able to do and what might not be a good idea to do since you're beginning a judicial process, and there may be things that you do that simply look bad in the eyes of a judge. You don't want to be treated as if you're hiding assets or doing anything that's going to make you look less favorable during the process of divorce. But that said, there are still some important things to keep in mind. As you may know, under a lot of state laws, including New York, when somebody finally becomes divorced, the law rewrites their estate plan for them. The divorced spouse is written out of their will, written out of their revocable trust, written out of beneficiary designations, out of a power of attorney. But divorce can take a long time. And you may not want your spouse to be holding your power of attorney or your healthcare proxy or to be the executor of your will while you are in the process of divorcing. And so you may want to accelerate that process by making changes to the decision makers that you picked. You also may have picked your wife's or husband's friends or family members as decision makers under your plan. And that might not be the best idea when a divorce is happening. So you really need to sit down and think about, how does this change the way you're doing your plan? And And so, that's a conversation that I frequently do have. And typically, there's no obstacle to making those changes. If you're going to start moving assets around, that's the kind of thing where you want to slow down.
Yeah, or changing beneficiaries under your insurance policies. It's not so much estate planning, but there's some, connection there. Like there's certain things you should do. And I think, the power of attorney conversation, or talking to somebody about changing the power of attorney, or like you said, the healthcare proxy. If you might not want your soon to be ex husband or wife to be making these decisions for you anymore. So it's good to think about what's in place, is what I'm hearing, and decide what you can and can't do. Talk to your attorneys, and then take those steps that make sense for you, about basically around decision making during this interim period between I've asked for a divorce and the judge has issued the divorce. There's
Exactly.
a long time there.
Yes. And it's also important to look more broadly. If you've got inherited assets, and it could be anything as modest as a bank account where you were the designated beneficiary, or a full-blown trust that's been set up for you by your parents, you want to take a look at that to make sure that you're not doing anything that might impair its protection under the law. Typically, inherited assets are, separate property. But if you've been invading them to support your family, growth on those assets, these things can all be exposed if they haven't been protected in a prenuptial agreement. It's something where, if you are thinking about divorce but haven't yet started the process, you might want to have a conversation with your attorney, and with your family, your parents, whoever created the trust, the trustee of the trust, to see if there are anything that can be done to make that trust more protective from your benefit. There may be powers that you have over the trust that you might not want to keep if you are planning to get divorced. If you're in the middle of a divorce, again, got to talk to the divorce attorney to make sure that getting rid of those powers doesn't look worse than the benefit that you'd be getting by protecting yourself that way.
That's a really good idea. I mean, a lot of people, they don't wake up and say, I'm getting divorced, or I'm asking for a divorce this morning. They've been thinking about it for a year or 2 years or a decade. People, it's very hard to end a marriage emotionally as well as financially and practically.
Mhm.
So if you are considering, divorce, and you are the beneficiary of a trust, or, have created trust, the time is to do it before you announce that you want the divorce. It's a really good point. And speaking to your family, if there's family wealth there, that's going to be transferred to you, talking about making some changes there. It's not hiding things. It's just getting ducks in a row, basically. So it's less complicated later,
Sure.
Yeah.
And one of the most important parts of that little mental inventory that you want to do is thinking about the role that your soon to be former spouse plays in that planning. For instance, your spouse may be a beneficiary of a trust that you've created, or a trust that somebody else has created for you and your family. And that could be a very bad thing. It could be a good thing. Sometimes there are people who draw trusts that say, if the marriage ends, or not, maybe even before the marriage ends, if there is a triggering event, somebody files for divorce, you treat that non-family member spouse as deceased. You're automatically kicked out as trustee, as beneficiary. Sometimes that can work well. There was a situation I had where a client of mine came to me post-divorce, and it turns out that the spouse was a continuing beneficiary. There'd been no provision at the time of inception to say your interest terminates at divorce. And because of the powers and rights that this spouse had in the trust, the person who created the trust, my client, the former husband, was stuck with the tax bills for this trust. He didn't mind that the spouse was potentially going to get the money out of the trust, but he didn't want to pay taxes on the trust income. What we ended up doing was devising a strategy that would allow him to keep using his remaining powers over the trust, effectively to threaten, almost to pilot the plane into the ground, if the spouse didn't bend on modifying some of these powers and rights in a way that helped him out of his tax problem. And it was counterintuitive, because the very power that he was threatening to exercise were the powers that typically create the tax problem if it's not for a spouse. So, originally a lawyer had told him, you want to get rid of these powers. I said, no, you want to exercise them. So it was an interesting process. But when lawyers think something is interesting, frequently that's not a position a client wants to be in.
No,
that old Chinese curse, may you live in interesting times. My corollary of that is you do not want to end up a question on a law school hypothetical. The
Good
idea
point.
is to try and keep things simple, keep things nimble. And in this case, a spousal ejection clause would have solved the problem. But there's another side to that, Andrea, and that is that sometimes trusts can serve as resources that allow for what I'll call a better divorce. You have a pot of value that's been created right now. My client in this case, let's call it the husband, doesn't have any continuing benefit. He's not going to get the asset back in the divorce. The only two options are the spouse continues to benefit from it, or it goes to somebody else, presumably the kids of the marriage. And 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 in that case, a spousal ejection clause may prove to be a very Pyrrhic victory, because if assets are taken off the table and the spouse can't benefit from them anymore, then it's entirely possible that the divorce court is going to turn and say, all right, now you're splitting up what's left.
Right.
And so you end up with less than what would have been the case if the divorce court had been able to say, okay, well, your ex is benefiting from this trust. She'll continue to benefit from this trust. Maybe we even terminate this trust and let her have it. And that way, more of your assets, Mr. Husband, grantor, are going to be protected in the divorce. So I'm not a big fan of a reactionary knee-jerk, let's put the clause in the trust agreement, because you never know if it's going to backfire on you. The only time I would actively favor it is when there are specific assets, heirloom assets you want to keep in the family, so that when the spouse is no longer part of the family, you would now have those assets transition to someone else.
Like certain homes or assets that came from the family itself, heirloom
Exactly.
assets. If somebody is considering divorce and they are the spouse who has created the wealth, or their family has created the wealth, versus the spouse who didn't, let's talk. I mean, you're talking more about right now the spouses who maybe had the wealth and what choices they have. What would you say for somebody who's more of a dependent spouse, if they're thinking about divorce and they know their spouse has a trust and they've been living off this money? Or is there anything different on planning for a divorce that you would advise to the spouse who has less
Well,
control?
I think in either case, you need to understand what your rights and responsibilities are. What is your relationship to this trust? If you're now the non-moneyed spouse, as we say, and you have the beneficial interest in the trust, and that interest isn't cut off by the divorce automatically, then you want to understand what is your relationship to that wealth. Who is the trustee? Is the trustee now going to be hostile to you because of the divorce? Even if the trustee is going to be hostile to you, that trustee has fiduciary obligations, and you want to be talking to your lawyer to say, okay, what do these words, health, education, maintenance, and support, really mean? Does it really mean what the trust says, that the trustee has absolute and full discretion to give me money or not give me money? The answer to that, by the way, is no. Trustees are bound by fiduciary obligations to consider the best interests of their beneficiaries, even if things have gone pear-shaped, as they say in Britain, and there's now a divorce. This trust can still be your resource if there's no language in the trust agreement saying you're out. And so you need to understand and hopefully develop a good working relationship with the trustee, especially if you're now, let's say that you were living not off the trust, but off of your spouse's salary. And now that's not going to be the case anymore. Maybe you're getting maintenance, but maintenance is not going to replace everything that the moneyed spouse has been contributing. So you're going to want to understand, what this trust can and cannot do for you, how it's invested, what you can expect to get from it, and that way you can start building out from the rest of your finances to say, how am I going to support my lifestyle?
How will I make this work? Okay, so that's thinking about divorcing, what they should be thinking about. What happens? What considerations should be given to the couple's existing estate plan during the divorce? Like, sometimes people have, come to us, and usually they've done some estate planning, not always, I have to say. Usually they have. There might be trusts in place. There might be at least wills. Like, how do you, as a couple contemplating divorce, not preparing for it, but in the middle of it, what do they need to talk to their divorce attorneys about? how do the trust and estates attorneys play into the process?
Sure. Well, I think that you need to take the families as you find them. And whether it's, I mean, ideally you're dealing with a not acrimonious divorce and you're looking at a conscious uncoupling where you simply say, okay, what about this plan is revocable? What about it is irrevocable? And you go from there. You look at each of the documents in turn. You have a will that says this is where the assets go when I die. You have trusts that are contractual arrangements that are designed to protect assets for specified beneficiaries and administered by one or more people, individuals, or corporations that are trustees. You have a healthcare proxy, somebody who's going to make medical decisions for you if you can't make them for yourself. You have a durable power of attorney, where if you become incapacitated, this person can pick up the ball and continue to run with it for you and make all sorts of legal and financial decisions for you. All of these things are likely to change as a result of a divorce. If spouses were looking to each other as their most trusted person, you need to reassess that. Most of the time, you're not going to want your divorced spouse playing those roles. I have had situations where spouses decide they don't want to be married to each other anymore, but they still trust each other to make certain decisions. And there's going to be a continuing role. You need the trust and estates attorney to reaffirm that, because state laws are typically going to cut that off when the divorce happens. And you can say, no, this is my ex-spouse. We're not married to each other. We're not living together anymore, but I still trust her to do X, Y, and Z.
But you have to sign new documents at that point.
Yeah.
There's like you said, upon the divorce,
Mhm.
it's assumed that this person does not have any rights to your
That's right.
anymore.
That's right. But even the flip side of that is, let's say state law does cut you off. A financial institution isn't going to know necessarily that you've been divorced. And so if your ex is not the most trustworthy person in the world and still has a document saying that he or she gets to sign documents for you, you don't want that document out there in the world. And so you want to take steps to put in a new document. You want to take steps to round up every copy that you can and notify every institution you're working with to say, this is revoked. Even if you don't have anybody you trust now, you want to tell people you do not have, this person no longer has the power to sign for me. Because that can lead to various financial crises, especially since there is typically a clause that allows for spouses to do unlimited gifting between each other. And rather than rely on the fact that, well, since you're no longer spouses, that clause doesn't apply anymore, and that and since you're no longer spouses, you no longer have this power because the state law says so. That's a little tough to enforce when the spouse has taken all your money and run to Brazil. So that's the worst case scenario. Obviously, has not happened in my practice. You don't want to be the test case.
Yeah,
so
happen.
It's good to do the full inventory, understand what each of these documents does and doesn't do, and say, how do we want it to change from there? And when we say that trusts are irrevocable, that doesn't mean that elements of them can't be modified. That can happen in a bunch of different ways. One of the key decisions that creators of trusts typically reserve the right to play around with is who the trustees are. And again, just because a person is no longer your spouse doesn't necessarily mean that he or she is the wrong choice to continue administering this trust. What if it's a trust for your children? If the two of you are good co-parents, even if you're not good spouses anymore, it may very well be the case that you want the mother or father of your children to be the one making those financial decisions with money that is no longer yours. You gave it away. You put it away for your children. So you don't, and sometimes taking a breath and thinking about this and getting the emotion out of it can help crystallize that decision making. Because it's not always easy to get to that point. But I don't like the idea of being able to say this can never work out. Because as I know, Andrea, that's something you strive for in your practice, that you want there to be a good post-divorce relationship. And I'm sure that's much more important when there are children in the marriage. So that would be an ideal situation where the spouses can use this financial relationship, as a way of continuing to cooperate even after their marriage is ended.
Absolutely. Yeah. And sometimes it might mean naming like a co-trustee, if that would make you feel any better. And, like making the mom, the trustee, maybe your brother is the co-trustee, so that there's some checks and balances there. But a lot of my clients, because we do help people divorce without acrimony as much as possible, we want them to have a good working relationship. after the divorce is over. Oftentimes, I do see that they are keeping the other parent as the trustee
Sure.
for the
And,
benefit of the children.
and even the substantive element of the planning, if you've got children, is something that ideally should be coordinated. Let's say that both spouses are somewhat moneyed spouses. They're not going to be going to the same lawyer necessarily to do their planning, but the idea of saying there's a coherent plan. For instance, let's make an agreement that if we're both gone and our children are minors, we want that this is who we want to be the guardian. It shouldn't rely on which of us happens to die last. And the substantive provisions. Trusts send a message to the beneficiaries. And there are different philosophies behind sharing wealth. Now, that's not to say that you can't have two different philosophies with mom's money or with dad's money, but if they're not coordinated, if you're getting mixed messages, that can really impair the family relationship. You could say you end up with the kids saying, "Gee, dad didn't trust me. Dad didn't want me to have access to my money until I was 50, and mom just gave me everything outright. I like mom better." That's not healthy. And the hopefully there can be an agreement that the common children are the beneficiaries of a common approach to wealth transfer, so that the goals that you have for them as a couple are still achievable, even though your status as a couple has changed.
It's sometimes couples do planning. I had a couple who had a trust created for their children, and it wasn't until the divorce negotiations, and it was a collaborative divorce case, and we were all talking about these trusts, and they only then realized that these children were going to get access to millions of dollars at the age of 21. And one of their sons was 18 at the time. And they were like, "What? How did we?" They had no recollection that they had been advised, or that all this money be coming. And they're like, "We have to change this now." So in the middle of the divorce, like, they got on the same page. They thought about different ages, and they changed the trust for all the children, because they realized, and the divorce was probably a good thing in that respect, because these children should not have had that much money.
I'm smiling because that's one of the most common conversations I've had. Typically, it's not about trusts terminating at 21. Typically, it's about custodial accounts terminating at 21. But I've had many clients freak out as their children reach that or start to reach that age, and they want to know what to do. And the conversation I have at inception to avoid that result has been one of the most humbling of my career, because it's shown me how old I've gotten. It used to be that the metaphor I would use for why you don't want your children to have $1 million at age 21 was them hiring Van Halen to play their birthday party, which is a reference to the movie Fast Times at Ridgemont High, which everyone in my generation recognized instantly. And lately, when I say that, the responses I get are blank stares or "Who's Van Halen?" and it's very depressing.
Yes, we are older.
But
Not old.
once I'm able to get past that, the message is very, very important. The idea that wealth is something that needs to be transitioned, that beneficiaries need to be prepared for the wealth, just as wealth needs to be prepared for the beneficiaries. That's why trusts exist. And decisions that you make when your children are infants or zygotes, or toddlers or teenagers, are not necessarily decisions that you're going to want to stick with. And if the decisions originated from you while you were a married couple, as long as possible, you want to make those decisions together, even after you're no longer a married couple. Because again, anytime parents, even divorced parents, converge, that mixed message can really hurt children. It can hurt them emotionally. It can hurt them financially. And so the more time you can spend on the same page, the better. And by the way, I mean, this has collateral effects, not just on the parents' divorce, but in the planning that individuals do. What I've found is that clients who come out of very bad divorces will be hyper sensitive to the possibility of their own children's divorce. And certainly, every client is free to set their own priorities in their planning. But it is sometimes, going in with the assumption that, anyone your child brings home, a potential son-in-law or daughter-in-law, is suspicious. And you must have the ironclad prenup, and your trust provisions will completely prevent any spouse ever from having any access to anything you've got, and will tie your hands behind your back before your husband or wife gets a dollar out of this thing. It's a tough starting point. And it's a starting point that can not only hamstring you financially, it's a starting point that can create, I mean, may almost make the divorce a self-fulfilling prophecy. Because if you go into a marriage and your wife's or your husband's parents don't treat you like the outlaw, that can create some pressure that can lead to some fissures later on.
Absolutely.
So it's something where I know how to protect assets from divorce, in creating trust. And if you want to make that a priority, we can. It's just that sometimes the decisions that you have to make have other collateral consequences. And as I point out to the client, spouses aren't the only family members who end up in big fights. If you're going to put Uncle Bob in charge of your daughter's trust, because because you don't want your daughter to have a say in that, what happens if Uncle Bob and your daughter start fighting and there's a breakdown in that relationship, where there's no divorce process for a judge to mediate? Yes, she can sue and engage in litigation against him as a trustee, which can be very, very expensive. Um, but really, the question is, how to calibrate these things, how to assess the risks properly, and look at the trade-offs. And when you're coming off of a bad divorce, it can sometimes be tough to see any other risks to the family's wealth.
You know, I I have a lot of clients who say, "I don't want my parents' divorce." And what I'm hearing you say is you have a lot of parents who are your clients who say, "I don't want my children to have my divorce." And they're looking through their marriages, their children's marriages as the lens of their own.
Mhm.
And you don't have to have your parents' divorce. Your children don't have to have your divorce. So that's why you can have a better divorce, and if you choose the right process. But the fact that you're advising them to think long term, think it's put on a slightly wider lens here as to what you're doing. I think it's great advice. So is there anything else that upon a divorce, when my clients are ready to sign their separation agreement, I'm starting to prepare them that they now need to change their estate plan.
Mhm.
And I'm encouraging them to go to their state attorneys, or I'll recommend somebody like you to go that they should talk to. When that person now comes to you and says, I need to start over here. Are there any more global questions that you might ask them, or advice that you would give, more generally at that stage when they're ready now to create the new plan?
I think I would encourage them to say, once you're through the process, and once you're free from your obligations, obviously you may have ongoing maintenance. There may be some continuing deferred payouts from the equitable distribution, but assuming all of that is over, you have a chance to take a fresh look at your balance sheet. This has been a major life event, and frequently after major life events, people get reflective. So part of the thing is to say, okay, what's left for you? What is the purpose of this wealth? Now that you can't, if we're assuming, as you always do in the process with me, that you're not here anymore. The reason I have a job is the old maxim, you can't take it with you. So since you can't take it with you, what is going to happen to it? Who are the decision makers? What are the rules? And who's getting it? And thinking deeply about how divorce has changed that, can be a very constructive and healing process, and saying, okay, this is what I'm left with. And what lessons have I learned? What are my aspirations for my children? Not thinking in terms of, they're going to get divorced and I never want my son-in-law or daughter-in-law to get anything because he's the bad guy or she's the bad guy. But just thinking more creatively about it, and thinking, what message do I want to send my children, both in the communications we have during our lives and, post mortem, after these assets are still here and I'm not. And a lot of that is about who you decide to pick as a trustee, the messages you communicate to the trustee, and the messages the trustee communicates to the beneficiary. And we'll talk about other things like, tax planning opportunities. Frequently clients come to me because they know I can save them some money. The one thing all of my clients have in common is that they don't want to pay the government more than they have to. And they know that I can help them reduce that bill when they're in that bracket that pays. But once you get through that, that's where the interesting conversations happen, because every family is a little different. And once you get post divorce, your family is a little different. And so the question is, okay, what now? How do you define your relationship to these people who are now your beneficiaries? And if you don't have kids, you've got a wide playing field ahead of you. You should still have a will. If you're worth millions of dollars, somebody ought to get that, presumably somebody you care about. Maybe you want to leave everything to charitable institutions. You could simply write a will that names a bunch of charities, and that's that. You could look to do lifetime planning, where you can, keep some benefit, give some benefit away for the future, and get some tax benefits as well as some thank yous now. Yeah. Or you could look to structure something a little more permanent with, private foundation, with people you trust administering that and fulfilling your charitable goals over time. There may be extended family members you want to help out. Again, some people look at a will as this distant document, and they say, well, I'm just going to, if I die, then this is who I want to have what, and it's an inert thing until it's no longer inert. But if you think about it carefully, and there are messages you want to convey with this, the money can end up having more meaning than a simple plain words on paper that people pick up after you're dead, and people get checks and they put them in the bank, and maybe they think fondly of Uncle Michael, and that's that. Mm-hmm. But the key is how much meaning you want to put behind your plan, and how that meaning has changed now that you're no longer part of a married couple.
Right. Yeah, it's time that you can be creative. You can think about what's important to you. It's not, you don't have to please your spouse or make decisions with them or think about what they're thinking. It's a whole new time to wipe the slate clean, really, and you have a fresh slate, I guess.
It's a restart.
It's a new start. All right. Well, my final question for you, Michael, which I'm asking all my guests, is what's one tip you can offer to help ensure a better divorce?
Okay. And it's a two-part answer. A properly drawn prenuptial agreement at inception can take a lot of the acrimony out of divorce because it removes most of the financial issues. And properly planned trusts that fit your family's needs so that everybody is on the same page as to what they do and what they don't do. You've simply set things up economically so that there's less to fight about. Now, couples who are inclined to fight can fight about anything, but at least if the subject matter is restricted because everybody knows what the deal is going in, this is what you can have, this is what you can't have, this is what we've agreed to, then that I think creates a climate for stepping back, not letting those remaining issues become sources of pain, and in disengaging more pleasantly.
Yeah, right. The more clarity you have around and when you're able to plan, when you're calm and that marriage is happier, or before your marriage, the easier you'll be, and a better divorce you can have. If it does end. So thank you, Michael. I really appreciate our conversation today. And what is the best way that someone can get in touch with you?
Someone can get in touch with me through my firm's website. I'm at www.lowenstein.com, Lowenstein. You can see my bio. You can see articles I've written, all of the little details about me. I'm wearing a tie in the picture, and that has all of my contacts, including my telephone number and my email address.
Thank you so much, Michael. And thanks, everyone, for listening. This was Andrea Vacca with the Better Divorce Podcast.
Thanks, Andrea.
Thank you for joining today's episode. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.
You've been tuning in to another episode of a Better Divorce Podcast with Andrea Vacca. Thank you for subscribing, leaving your positive comments and reviews, and sharing the show with others. You can watch episodes at vaccalaw.com, YouTube, LinkedIn, and Facebook. And you can listen through Apple Podcasts, Spotify, Google Podcasts, and more. Bye for now, and remember, you can have a better divorce.